Good afternoon, everyone. Welcome to the Civil Justice Academy. Today's webinar is on state and federal private right of action legislation. Are these mechanisms wise or worrisome? This is sponsored by the Law and Economics Center here at George Mason University's Antonin Scalia Law School. I'm Donald Koshin. I'm a professor of law and also the executive director of the Law and Economics Center here at George Mason. And I'll be the moderator for today's discussion. This webinar is designed around the mission of the Law and Economics Center to serve as a nexus for academic research and education that focuses on the timely and relevant economic analysis of pressing and interesting legal issues and public policy issues confronting judges and policymakers nationwide. Our commitment is to developing original, high-quality law and economics programming, much like what you're seeing today, to further economic understanding and to provide information that is useful in the legal and public policy debates surrounding those issues. We thank you all for joining us and being part of this ongoing dialogue. Our panel of experts today each come to the discussion with impressive backgrounds, researching, teaching, and analyzing the law, including with specific expertise in evaluating the pros and cons of private causes of action, private rights of action, including those that are in legislation. So that we can reserve time for substantive discussion, I'll be only giving brief bios. Please do visit the email that you received for this program or go to masonlec.org where you can read the full bios and extensive experience and expertise of our panelists. Our panel includes today, we're starting off with Matthew Shapiro, who's an associate professor of law at Rutgers Law School. Actually, we'll be starting off with Karen Harned, who's the executive director of the Center for Constitutional Responsibility, Inc. And then we'll go to Matthew. And then we'll close with Richard Epstein, who's the Lawrence A. Tisch Professor of Law and the director of the Classical Liberal Institute at NYU School of Law. Today's webinar will be 90 minutes. This is slightly longer than our typical webinar, but we thought that the issues here deserved a little extra airing. Each panelist will speak for about 15 minutes to summarize the relevant law and analyze recent legislation at the federal and state level and current proposals at each of those levels as well. Afterwards, we'll have some intra-panel discussion between the three panelists, and then we'll move to audience Q&A. If you have a question, please use the Q&A button at the bottom of your screen. And I'll be looking at those questions throughout the presentation, so you can post them at any time. And we'll start posing them to the panelists at the close of their opening remarks. Please identify yourself in the text of the message and keep your questions short so that we can readily incorporate your questions into this online format. With that, I'm excited to hear this discussion on private rights of action, and we're going to start off with Karen Harned. So Karen, please take it away.
Thanks so much for having me, Donald, and thanks everybody for joining us today. This is a topic that's near and dear to my heart. As the executive director of the newly created Center for Constitutional Responsibility. One of our big issues is, in fact, challenging and fighting these private rights of action that really have been in existence now for decades. We believe that, it's really the responsibility of, the attorneys general, the federal attorney general, the state attorneys general, to enforce the laws of our country that really are for the benefit of all of us. And that's really what this private right of action that we're concerned about and that we're going to be talking today entails. It's where you have a statute that is for the public good and incentivizes and or allows private citizens to enforce it. We think these laws really, they're unaccountable to the public, right? Because we've got private citizens enforcing them. We think there's some serious constitutional questions when it comes to executive delegation to the citizenry to enforce the laws. You're not going to have the benefit of enforcement discretion that you would get when the government does it. And we just think that they're bad policy, and in a day and age where we're really uncivil enough, not a great idea to have us, quote unquote, narking on our neighbors. And that's really what these invite. So what are some examples that I'm talking about here? Well, actually, the Supreme Court's going to be hearing a case next year or next term on the Americans with Disabilities Act. This is a perfect example at the federal level of what I'm talking about. With the Americans with Disabilities Act, businesses of all sizes have to ensure that their accommodations, if they're public, are accessible to anybody that wants to frequent them. And, there's certain, carve outs for smaller businesses. But once they do a renovation, they're under the same rules as everybody else. What we have seen for literally decades is, especially in California, there has been a lot of so-called tester plaintiffs. And this is actually something the Supreme Court will be checking on it or looking at the standing of these tester plaintiffs. Well, what's a tester plaintiff? A tester plaintiff is anybody that wants to sue on these laws and says they go into a business and they see that, your guardrail is 1/4 of an inch off and sue you. Even if they're not disabled, they can do this. Any citizen can do this. We're seeing it widespread now, and the case before the court concerns websites. What does it mean for a website to be, accessible under the ADA? And people can literally just sit, these tester plaintiffs, in their homes and go and look at hotel websites, look at bank websites, look at all sorts to see if they've got these, if they're meeting all the statutory requirements. If they're not, many times they'll threaten litigation and say, if you do not, pay me X amount of dollars. I mean, it's literally extortion. And this has been, those types of cases, a lot of vexatious litigants have been shut down. But they will say something like, if you do not, pay me X amount of money by, X date, I'm going to sue you. And so especially a small business owner is going to do the calculation. They're going to pay the $5,000, $10,000 rather than worry about going to court. What's interesting about these plaintiffs is many of them have no desire to visit this business, have never even gone to it, never will. That's, again, the fact pattern at the case that the court will be hearing this next term. But the ADA is not the only one. We've got the Medicare Second Payer Act. We've got the Clean Water Act. Medicare Second Payer Act has a private cause of action that's detached from the injury to the plaintiff. It allows for a plaintiff to obtain a bounty for basically, filing, Medicare fraud actions. And they'll get people into, discovery to get more. And so these are private individuals that are, again, trying to help enforce the Medicare statutes. And the Clean Water Act and maybe even the Clean Air Act, but definitely the Clean Water Act. Oh, actually, Clean Air Act too. Private plaintiffs through citizens effectively act as bounty hunters. They get civil fines that are payable to the Treasury, and they get attorney's fees or settlements that can advance their agendas, again, enforcing these laws. So this has been an ongoing problem. And what we've actually seen more recently, and this was in the introduction to this webinar, the examples, is states are increasingly using these as well. The famous Texas abortion statute that was enacted 2 years ago, the heartbeat bill, allows any person other than the state government or a local government to enforce these laws. So if they find a doctor is performing an abortion outside of the 6-week time period, they can file an action against them. So what happened next? Not surprisingly, Governor Newsom said, you know what? If you're going to do that for abortion, we're going to do it for guns. So now we have a law in California where if you find that your neighbor got their uncle's shotgun as an inheritance or just a gift, didn't register it with the state, they could be, enforced against by a private citizen. Louisiana passed a bill last year that creates a private right of action for any website that facilitates distribution of material that's obscene to minors, unless the website has a verified age of the user. Again, no attorney general enforcement, only private lawsuits. There's a pending bill in California that would have a link tax where if you have Facebook, any of those social media, there's an article that they link to from another publication like CNN or New York Times or whatever, they would have to pay the media outlet for that privilege. Again, no government enforcement, only private remedies. For the many of you that are teachers and professors and intellectuals here, there is a great article that the Volokh conspiracy featured at the end of March of this year that is going to be forthcoming by Professor Zambrano, Guha, and Peters, all from Stanford. It's going to be published in the University of Pennsylvania Law Review. You can find it on SSRN. They have actually done a deep dive into what's happening in the states. I was even surprised to hear that there are thousands of laws in the states that have this. They said at least 3,500, but it could be even more than, it could be even up to 10,000, depending on how you count them. And they said the states leading the pack are Utah, New Hampshire, Connecticut, Nebraska, and Wisconsin. Why? And on the books already, again, New Jersey's Environmental Rights Act is another one where you've got these citizens suits, but they really scale the gamut of traditional law, state lawmaking power, including for veterinary care, pet services, and grave digging. They will, and I would also say that one of the issues that they point out in their article that I have seen firsthand as somebody that has worked as an observer on a uniform law commission is a lot of the states have these model codes that then they will use as, a blueprint for a state law that they will enact. And during that debate, there's often the issue of, will we do a private right of action? I served on one regarding privacy, and we are seeing it when we're looking at data privacy statutes. This is commonly debated. I don't know. I think California, if anybody's done it, California's done it. But other than that, right now, I do not think there's a private right of action in the privacy space, but that is definitely something that's coming up in that space. And why would a state be interested in doing this? Well, there's several reasons, some of which these authors in this article point to, which is the state AGs can only go so far, right? They only have so much bandwidth. They only have so many resources. So if you really want something enforced, let's, let the citizens do it. What if you have an agenda in your state that most of the citizens agree with, but you've got pockets of that state? If you're in a red state, but you've got pockets of blue cities, or you're in a blue state, pockets of red cities, and you're worried that you're not going to get any on the ground support from the local DA. Again, this is a great solution, they think. And so bottom line, those are some of the reasons why they think it's a good idea, but we really think it's a bad idea for some of those reasons that I articulated at the beginning. We're not going to have accountability for enforcement of laws if we're leaving it to the citizens. Anybody can do it. There's no measure of, scale. There's no measure of proportionality. There's no chance for the person that's being alleged to commit this violation to remedy it first, which in many instances, take a small business owner or just a common, citizen may not even know they're breaking the law, but it doesn't matter. A citizen can literally throw the book at them. And we also think even under state constitutions, there may be serious questions regarding executive delegation to the citizenry to enforce these laws. I'm really looking forward to hearing my other panelists and their observations with regards to this and our conversation that follows. Thank you again for your time.
Thank you very much, Karen. We'll turn it over to Matthew Shapiro. Matthew.
Great. Thank you. Thanks to Professor Koshin, to Professor Epstein, to Ms. Harned. This is, I think, a really important conversation to be having, and I'm honored to be part of it. So the U.S. legal system stands out in a number of respects when you compare it with other systems around the world. But one of its most notable features, I think, is the extent to which it relies on private lawsuits to enforce regulatory policy, particularly at the federal level, but as Ms. Harned was just alluding to, also widely at the state level as well. And it really runs the gamut, right? We have statutes like Title VII of the Civil Rights Act of 1964, which creates a cause of action for claims of racial and other forms of discrimination. We have the environmental statutes, which have these citizen suit provisions. Even ordinary tort suits, right, can be construed to some extent as a way of enforcing regulatory policies. products liability, for example. This choice that we've kind of stumbled into, so maybe not so much a choice, has been controversial from the beginning. There have been arguments for and against relying on private lawsuits to enforce regulatory policy. But at least, within the last decade or so, those debates had kind of reached a stalemate. The lines of battle were well drawn, and people knew where everyone stood. And then the statute that Ms. Harnett alluded to, the Texas abortion bill, SB 8, came along and kind of blew everything up when it came to this conversation. So, as I'm sure most people know, that bill, this was before the court overruled Roe v. Wade and Planned Parenthood v. Casey and Dobbs, banned abortion before a fetal heartbeat had been detected. Those abortions were at the time protected under Roe and Casey. And it authorized, and this is the key feature we're obviously focusing on, authorized private parties rather than government officials to enforce that ban through private lawsuits. And so the question that I think is most pressing is, how should we think about these kinds of private enforcement regimes as a normative matter? Are they good or bad? And in particular, what values do they implicate, potentially promote or undermine? And what normative criteria should we be using to assess them? So that's what I'm going to focus on in the rest of my remarks. But before getting there, I think it's also important to appreciate how regimes like SB 8 do and don't differ from other kind of more traditional private rights of action. So I just want to draw quickly a few conceptual distinctions before getting into the normative criteria. So as I was suggesting, private rights of action include ordinary tort and discrimination suits, also these citizen suit provisions, qui tam actions under the Federal False Claims Act, and obviously regimes like SB 8. And so there are kind of two, I think, at least two important distinctions when we're thinking about these regimes. So one is the degree of connection that's required between the plaintiff and the subject matter. What kind of interest does the plaintiff, if any, does the plaintiff need to have in the subject matter of the action? So obviously, substantive law can require a concrete connection. To bring a tort suit, right, you have to at least allege that you've suffered some kind of injury caused by the defendant. Same also, though, for an ordinary discrimination claim under Title VII of the Civil Rights Act, or even the ADA. Maybe not so much with the tester cases that Ms. Harnett was alluding to, but at least, if a disabled person claims that she wasn't reasonably accommodated, she needs to allege some adverse action on that front. Then there can be statutes that don't require that concrete connection. Here I'm thinking more about citizen suit provisions and environmental statutes. But when you map those statutes onto standing doctrine in federal court, you do get a kind of concrete injury requirement, because the Supreme Court has interpreted Article 3 of the Constitution to require a plaintiff suing in federal court to allege some kind of concrete injury caused by the defendant's action. Obviously, not all states have that same standing requirement, so it might look different in state court. What's remarkable about SB 8 is it goes even further than those citizen suit provisions and just empowers any person without any connection at all to sue anyone who performs, aids, or abets an abortion. So that's, again, one way I think we can think about or distinguish these different private rights regimes, how much of a connection the plaintiff needs to have to the underlying subject matter. The other is what kind of regime, what kind of incentives does the regime create for the plaintiff to sue? So typically, under the American rule, each side bears its own costs, or most of its own costs, and particularly its own attorney's fees. There are special fee-shifting statutes for certain kinds of claims, but for the most part, each side is paying its own lawyers. SB 8 again departs from that rule. So a prevailing plaintiff is entitled to a minimum damages amount of $10,000, plus costs or fees, but defendants have to bear their own costs under SB 8, regardless of whether they win or lose. So this is creating a very strong incentive, or removing disincentives, depending on how you look at it, for plaintiffs to bring these kinds of enforcement actions. So that's another feature that distinguishes something like SB 8, and something we should kind of be paying attention to when we're assessing these regimes. So how do we assess them? What criteria should we use? What values do they implicate? And what I want to suggest is there's no kind of simple answer to this, because they implicate a wide range of values that conflict with one another. And also the same regime can kind of promote and undermine the very same value, depending on how you look at it. So at the most kind of superficial level, we could just look at these in terms of partisan politics, or even just the underlying subject matter. Do you like abortion? Do you like gun rights, right? If you don't like abortion and you like gun rights, you'll criticize SB 8 and you'll support California's gun bill. You know, that's a principled approach. There are moral and political principles underlying those judgments, but it doesn't go very deep, and it doesn't really identify anything particular or distinctive about these kinds of regimes that maybe should concern us. So I'm not going to spend too much time on that. Ms. Harna is focusing on constitutional questions, and I think we can look on the constitutional level at both the substance of these laws and the procedural form that they take. So in terms of substance, right, there was an argument that SB 8 was unconstitutional because it was designed specifically to chill the exercise of what was then a constitutionally recognized right. You know, I don't think similar substantive constitutional arguments have necessarily been made about other kinds of statutes, although, you know, you could challenge an environmental statute under the Commerce Clause or something like that. Then the question is, well, are there any procedural kind of formal problems with these statutes from a constitutional perspective? So Ms. Harned is making a kind of non-delegation, private non-delegation kind of argument. You know, a few years ago, before the current composition of the court, I might have said those were kind of out of bounds or pretty aggressive kinds of arguments. You know, with a changing court that's potentially more receptive to these kinds of structural constitutional arguments, we may see those arguments get more momentum in the coming years. But more generally, when we think about constitutional, excuse me, questions, I guess the question is how much of these policy choices, and I think these are essentially policy choices, how much enforcement power does the government want to delegate to private parties? Do we want to constitutionalize? Do we want to kind of take off the table and remove from the democratic process? And so I think that's a difficult question. And the reason is, again, because I think it implicates, these statutes implicate really fundamental values. So just to take a few, you know, there are dignitarian and autonomy interests at play here, kind of on both sides. So in terms of the plaintiff side of things, there's a kind of dignitarian interest in being able to hold others accountable, to demand an account for legal violations. There's a narrow form of accountability, right, where the plaintiff is demanding accountability from someone who allegedly injured her, as we see in tort and maybe discrimination claims. Even in SB 8, though, there is a form of accountability holding. You've violated a public norm, and there's some dignitarian interest in a citizen being able to call another citizen to account for that kind of violation. On the other hand, right, there are dignitarian interests on the defendant side for sure. There's a risk that, you know, it's, you refer to vexatious litigation, that it is just kind of a nuisance suit or something like that, and someone's kind of being dragged into court on a purely frivolous claim. And so that kind of sounds in due process type concerns. There are also efficiency or social welfare considerations. So these kind of private enforcement regimes have traditionally been justified in terms of optimal deterrence. And Ms. Harned, in referencing the Pennsylvania Law Review article, Professor Zambrano and his students mentioned this kind of argument that, you know, you have conduct that you want to deter, but you don't necessarily want to over deter it. Government enforcers have limited resources, they have limited time. Government agencies are potentially subject to capture by the groups that they're regulating. One way to avoid those kinds of problems is to delegate some of this enforcement authority to private lawsuits. Of course, there's also a risk, on the other side of over deterring the relevant kind of behavior. And if you take a regime where the plaintiff doesn't have to have any concrete connection, then they don't have as much skin in the game, so to speak. And so they may bring these lawsuits where that would not optimally deter the conduct, but would over deter the conduct. Another value that's been invoked and that Ms. Harned, I think, implicitly invoked when she was talking about accountability is democracy. That these kinds of regimes are in some sense undemocratic. So on the accountability side of things, that these regimes kind of undermine democratic accountability, I think that argument sweeps pretty broadly. So for one thing, these are all democratically authorized enforcement regimes, right? They've gone through the legislative process. The Texas legislature chose to implement SB 8 and so on. We might think, well, each individual lawsuit needs to somehow be accountable to the people through elected officials. But if we situate SB 8 and other statutes on kind of a spectrum that includes even ordinary tort lawsuits, which again, even though there's a concrete connection, are still enforcing regulatory policy in some sense, there's a question of, well, how accountable are those actions, and do we really want to say that those even ordinary tort actions and discrimination actions are also democratically unaccountable? From the other side, the SB 8 has also been criticized as anti-democratic because it's kind of pitting citizens against each other. But that kind of critique raises similar kinds of questions in terms of, the statute is democratically authorized. What I want to suggest is the real value that's at stake in these kinds of arrangements is the rule of law. And there are kind of two general rule of law principles that I think are implicated here: legal equality and the impartial administration of justice. So in terms of legal equality, there's a concern about stronger parties using private rights of action regimes like SB 8 to oppress weaker or marginalized groups. There's that risk really in any private right of action, even an ordinary tort suit, but it seems to be especially acute in regimes like SB 8, which don't require any kind of concrete interest between the plaintiff and the subject matter of the suit. And then in terms of the impartial administration of justice, private enforcement introduces and depends upon actually a degree of partiality, right? It's kind of piggybacking on the incentives people have to bring these lawsuits to realize the kind of regulatory benefits of that enforcement. But and so that is itself a rule of law benefit, right? That we're enforcing legal rights that have been recognized by the legislature and ensuring that they're actually enforced in practice. Can also have drawbacks, though, in terms of the impartial administration of justice when there's too much partiality, which I think is a concern, again, with SB 8, especially in conditions of political polarization. So I guess the upshot of all this is a little messy, which is that these private enforcement regimes, depending on exactly how they're configured, implicate a wide range of values that kind of conflict with each other, cut in different directions. So I don't think we're likely to be able to make very broad generalizations about private rights of action in general. Instead, I think we're going to have to make kind of more context-specific, discrete determinations based on the specific procedural features of these regimes. And in my book, I consider that a reason to maybe make some of these choices of institutional design democratically through representative processes rather than through constitutional decision-making in the courts. Thank you.
Thank you very much, Professor Shapiro. And our final opening remarks will come from Professor Richard Epstein. So, Richard, Take it away.
Thank you very much. This is a very vexing topic, and I think it's really important to get a little bit of historical perspective on the way in which it is done. And so, as fits my training as an English lawyer in my earliest days, I'm going to start with stuff that took place a long time ago and then try to show how it turns out to be roughly. The question of whether or not there's a private right of action for individual tort injuries, the sort of question that Matt just raised, is one that was answered pretty decisively as early as around 1700, when Lord Holt said if there's a statute that creates a right, any particular individual who's injured in consequence of a breach of that statute has a private right of action. And if you start to think about it, this is not a particularly adventurous type of situation. So it turns out, suppose there's a statute which says that you have to stop at a red light, and defendant decides to go through the red light and injures plaintiff. Can the plaintiff essentially plead a case which says that the defendant was in breach of its statutory duty? And the common law answer to that particular question was really quite emphatic. These are cases of individuals who have very, very serious harms amounting to thousands or even millions of dollars. If it turns out that the only person who can enforce the traffic light ordinance is the state, they're going to go uncompensated, and the defendant is going to pay a $25 fine or maybe lose his license. And so everybody has taken the position that to the extent that there is a serious personal injury associated with the case, what happens is you have a rule which goes exactly in the opposite direction. It's a rule of what they call negligence per se, in which it turns out that you basically have a prima facie case and only very narrow, limited kind of excuses that allow you out of it, a dementia or getting a heart attack or something of the sort. And what happens is this is commonly justified on the best of all grounds, that it does protection for individuals, so it serves the compensation objective of torts, and it has a strong efficiency type of situation, because if you only have fines of one kind or another, there's going to be systematic underdeterrence of the particular statute. So I think that virtually everybody believes in that. And the transformation that comes in the modern statutes, as Karen starts to say, is what you do is you allow the private right of action when it turns out that there's no particular form of injury subject by this particular plaintiff. And if you realize that, what happens is the older regime is one that essentially said the person who was injured could sue, but nobody else can sue. And the new one says is we dispense with the requirement of injury whatsoever. So now what happens is you run the serious risk of overdeterrence. And this then brings you back to the question of how you try to deal with diffuse injuries on the one hand and concrete injuries on the other. And the leading case on this, which essentially carries itself through to American law and to American constitutional law, is a case boldly entitled Anonymous, which was decided in 1535 or 1536. And what happened is there was a situation on a public road in which it turned out that somebody created an obstacle so that horses and carriages could not freely pass along the road. And the question is, what's the remedial structure that was put into place? And essentially what the judges said, for large diffuse injuries, in which in this particular context would mean a delay in your ability to get to one location to another, there's going to be no private right of action because there'd be a multiplicity, they'd be very difficult to measure actual damages, the litigation costs proportionate to the amount of harm stuff does not make this an attractive proposition. But if you look one step further and you say, if there's no private action, there's no relief at all, then there's going to be massive underdeterrence against these kinds of situations. So what the early English court said was there is something, an administrative body, which they called the court of leet, and that it was entitled to do two things. One, to remove the obstacle so as to restore the traffic, and two, to put a fine on the particular defendant to act as a kind of deterrent. So what happens is the administrative remedy now is proportionate to the disparate diffuse harms that one sees. But suppose it turns out that there's somebody, and what happens is the barrier is put up, they can't stop, and they veer off the road, and they suffer serious physical injury. And the other case that was given, suppose there's a barrier on the public road, and it turns out that somebody cannot get onto his own private land. At this particular point, there was introduced into the system another distinction called special and general damages. And the applicable legal rule said that if you were a person with special damages, you could bring the private right of action just as anybody could in an ordinary tort suit. And that particular accommodation seems to work extremely well, and it has managed to make its way through all modern laws. So if you start talking about people trying to bring constitutional actions for blockage of public rights of way with new public works actions, generally speaking, they'll give compensation for special damages, but not for general harms, and will try to handle that through the taste system generally. Now, when we come to the modern context, it turns out that the public rights of action often take a very different form, and one has to spend a lot of time thinking about what that is. And so if you take something like the National NEPA, the National Environmental Protection Policy Act of 1969-1970, what it does is it creates a very elaborate scheme in which it turns out there's a form of participatory democracy, the democratic value that Matt referred to, which allows you to try to figure out what kind of activities should be taken in order to approve facilities that have vast impacts on large numbers of people within the system, building a dam along a river or something of that sort, building an airport, where the consequences are extremely wide and are extremely diffuse. And the question is, how do you run this kind of procedure? And the first thing is that you do have a strong vector in favor of participation. You do not want something to be put up on the river and then tell the naturalist, you can't talk about this particular thing, even though fish and other wildlife are going to be destroyed. You don't want to ignore farmers because the particular actions might cut off their access to the water, which they need to water their crops and so forth. There are people who are running the transportation system. And so what you discover about a regime for water, and in some cases for air and for land, there are multiple uses that are implicated in these particular situations. And to run a public hearing that simply excludes them from participation is a terrible art. If you let some in and keep others out, you're going to get a very skewed kind of result. So the basic notion is anybody can come through the administrative law process and through notice and comment participate in the kind of decision that's in question. And I think that's all to the good. The question then arises, what happens when somebody disagrees with this particular decision? And if you look at the original structure of the NEPA statute, there was no provision whatsoever for private rights of action. If you start looking at the first of the major cases, which was a case called Calvert Cliffs, which was decided by the very adventurous Justice Scully Wright back in 1971 or so, what he did is he said a private right of action is going to be perfectly appropriate in order to challenge the decision that were made by the administrative body. Now, this is a profound alteration of the particular scheme. And what it does is it creates a lot of asymmetrical interest. If you're a public utility and so forth, and you get a permit, nice, you're going to defend it. If you lose the permit, it's going to be extremely difficult for you to overcome the judgment of these bodies. But what he does is he says anybody who doesn't like it and thinks that the permit should be denied can go to court to challenge it. So what happens is you completely change the center of gravity in the way in which these statutes work. If you run it through a collective deliberative process and make sure that everybody has a right to present evidence of one kind or another, you will get some kind of a median voted decision. But the moment it turns out that you let any environmental group, which is opposed to the statute, go into court and to force people to start over again, what happens is the emphasis shifts from the median voter in these cases to the extreme voter on one side of the particular case. And this transforms the way in all which these statutes start to work. Now it turns out that they are recipes for delay, and there may be a huge public sentiment on one side or the other, and it's not going to be honored. And if you look at the subsequent history of NEPA, virtually every case in which it's applied, there are a couple of notable exceptions. What you see is somebody raising a deep and searching objection to the creation of a pipeline on one side or another, and they find some particular kind of environmental harm. And then they say you have to go back and reconsider it. Everybody says that when you're dealing with NEPA, it is only a procedural statute, it's not a substantive statute. But the procedural bars are often, in many cases, set so high that what really happens under these circumstances is that it works as an effective veto right. So there was a recent case in the Supreme Court where they said with respect to a particular pipeline, you cannot require a separate environmental pipeline review for every river under which this pipeline is going to go or over which it's going to cross. There'd be 300 of them. And so the Supreme Court gave a big victory to the company. But then you realize 3 weeks later, a month later, it abandons the pipeline in any event. because the other NEPA objectives were completely cumulative. And when you start having people saying, well, you're going to put a pipeline into place, and now what you have to do is to run a climate impact on that, what they're doing is they're making believe that there's some very distinctive features about pipelines when virtually all of them, given modern construction, have the following characteristic. And they emit very few fumes of any sort. And if there are any leak in these things, the devices for capturing it are extremely great. And so what you do is you magnify the importance of the objections relative to their actual strength, and you stop things in their tracks. And this country today has major shortages because you can beat any pipeline under these kinds of conditions. So the Northeast ends up importing Russian oil and gas into its ports in order to serve a market which cannot be served by American pipeline. Well, this stuff, to my mind, now starts to reach the level of general insanity, going so far, wrong substantive standard, and the private right of action is a very large piece of the particular problem that is played. Now, there's another role, which I want to mention very briefly, about potential dangers associated with statute, which takes a very different form. There are many statutes which create private rights of action. And as I've indicated, if you've suffered an actual harm, private tort action in the usual way, showing causation and so forth, is appropriate. But there are other statutes which have defensive purposes. And so if you want to explain what the source of the huge rise in private liability, product liability is a subject that's been mentioned, there are a number of cases going back 50 years ago when this field started to take off, which say the following very innocuous proposition. If there is a determination by the FDA that a certain product is safe and effective when put onto the market, a jury is entitled to say that's just a minimum standard that the FDA proposed, and you can decide to find huge tort liability for somebody who meets the standard, but nonetheless does not solve some cost-benefit analysis. And so you start looking at this and what does it entail? Today, the number of cases where people put onto the market products that don't satisfy known standards in advance is virtually zero. Occasionally, you'll have a construction defect or a warning mistake, but the quality control devices in place are so strong that these things are very unlikely to happen. On the other hand, if you have a rule which says you can always go beyond what the statute requires, every single case of an injury involving the use of a particular product is going to be subject to controls by a jury. Now, why is that the particular case? Because the abstract standard which the FDA is trying to apply is whether or not a particular product is safe and effective for its purposes. All medical products have adverse side effects. So this standard is not one for saying you can never give a drug with a side effect. It's a standard that says you have to warn. And any warning that you could give at one level, you can make more intense at another level. So what happens is there'll be no summary judgments that will take place in this state, except in very rare circumstances. So the potential exposures are absolutely enormous, and they could apply to entire product lines like Prozac and so forth. This is a very dangerous development in my view. And I think the correct way to do this is to say we really respect these determinations. The FDA, if anything, is a risk-averse operation. And if it's willing to give an approval, the idea that there's some lurking massive hazard in this particular drug is very remote. So the correct memory is to get more information and then update the warnings as this stuff comes in. And I've seen a large number of these cases. And it turns out that the market moves extremely fast anyhow, because if there's a drug which is approved and it doesn't meet with patient satisfaction, it dies. So you don't want to create that kind of a system. So I think using statutes for defense is very appropriate. I think on the offensive side, it's appropriate in the case of a breach, but that the flip side should be that where there's a defense, what you have to do is to figure out by going back to the system, what is wrong with what's happening. So on that particular mode, I think there's a part of me that agrees with Matt, which says that we got a lot of difficult judgments here, and a part that agrees with Karen in terms of the possibility of abuse. And I think that the kind of framework that I've put together is a way to reconcile these conflicting impulses. Thank you.
Thank you very much, Professor Epstein. We'll take a few minutes to talk amongst the panel. Karen or Matthew, did you hear anything that you want to respond to, and or any additional thoughts in light of what your fellow panelists have said? And then Richard, please also feel free to engage in that. Karen? You're muted.
Yeah, okay. No, well, what I guess with regards to Matthew's presentation, I really think, he touched on something that I think is, well, and he viewed it as a problem too, which is the infringement on individual rights. Like, so at the time that the Texas law was first enacted, that was opposite of what Roe allowed, right? But then on the California law that I referenced with regards to guns, that's a Second Amendment violation. And I guess again, when you've got the citizens that are the ones enforcing, they're not going to appreciate nor care about the nuance. I also think this invites big money, dark money that I'm told we don't like, to get behind an effort, right? And encourage this kind of grassroots litigation. And I just again think that it's really incumbent on our elected officials to directly enforce these laws as opposed to all of us.
Matthew? Matt?
Yeah, I don't have too much. I mean, just following up on that. I mean, putting the 2 points you just made together. One, that these different regimes can kind of be used to subvert existing substantive rights by chilling their exercise, and arguably the SB 8 and the California bill are designed to do that. But also, that seems maybe somewhat orthogonal, or not orthogonal, but not directly related to the issue of executive versus private enforcement. It's connected in the sense that one of the reasons you outsource the enforcement is to make it more difficult to challenge what would otherwise be substantively unconstitutional law. So as we saw with SB 8, abortion providers tried to bring a pre-enforcement challenge before any of these private lawsuits had been brought against abortion providers. And the Supreme Court, for the most part, rejected that pre-enforcement challenge under various federal courts types doctrines, Ex parte Young and so on, in Whole Woman's Health v. Jackson. Nevertheless, though, had any of the private lawsuits been brought, it would have been open to the defendants named in those lawsuits, the providers themselves or people who aided or abetted the abortion, to raise, at the time, Roe v. Wade, Planned Parenthood v. Casey as a substantive defense. So it's not kind of completely circumventing. But I think, again, if there are distinctive problems about these regimes apart from their particular substance, it has to take the form, and this goes to Professor Epstein's remarks as well, of the concrete stake that the person needs to have in the action, and also the incentives that are created to bring these lawsuits. And just on the concrete stake, there are also examples where Congress or state legislatures are recognizing new kinds of injuries that weren't traditionally recognized as concrete injuries at common law. And I do think it's important to allow at least some degree of evolution and development in recognizing new legal entries. Take privacy, right? Which wasn't necessarily recognized in early common law, but then toward the end of the 19th century became a kind of cognizable injury. So with that caveat, I do have the same kinds of reservations about someone having no stake at all in the lawsuit, being able to sue and to hail someone into court. But on the other hand, I do think we should recognize a fairly wide range of cognizable injuries.
Yeah. I think Matthew is the soul of prudence, which is both a virtue and a risk in all kinds of intellectual endeavors. So let me make a couple of points which I didn't get a chance to talk about in my original remarks. SB 8 is a very unique statute. It was put together by one of my students, Jonathan Mitchell, who's one of the genuinely most original minds when it comes to this. I thought he was wrong, and we had a debate, but it was a very unique statute. What his position was and that when you have a statute that is declared unconstitutional by a court, what it does is it renders it unenforceable by the Attorney General. But it doesn't preclude anybody else from making the enforcement. So he says, given the nature of the wrong, it turns out the injunction only goes against public officials, but not against private one. My view is it was actually somewhat different. As you go back to the original formulation that you have in Marbury v. Madison, the judge, Marshall, was very emphatic that the statute was void. And if the statute is void, it's basically non-existent. And if it's non-existent, you can't have its private enforcement. And so I always thought that SB 8 was wrong. Now, when it starts coming into the question of trying to do it the other way, it's a little bit odd. If it turns out that what you do is you leave the question of the enforcement of gun legislation to the legislature, and it has all sorts of mechanisms, then in effect allowing somebody without special injury to sue in any particular case strikes me as being unjustified. And you don't have the peculiar Mitchell justification of saying the statute's still on the books, it can't be publicly enforced, but it can be privately enforced. Now it can be publicly enforced. So it seems to me you really do not want to go down this road of having all sorts of private parties do it. And the second point relates to something that Matt said. He said the right thing, but got the wrong conclusion in my judgment. What you said is the dignitary interest is essentially ubiquitous, right? It's on the plaintiff side, it's on the defendant side, it's in every case. Anybody who loses feels hurt when they feel offended to their dignity. If a notion is that ubiquitous, it can't be used for any particular purpose on either side. So what you really have to do is to find something else that will break it. So when you go back to the privacy cases, he's quite right to indicate their sort of private law evolution. It starts in effect, and actually in a very defensive way, with the Brandeis and Warren article, whereas for the most part, if you read the article, it's designed to say that there's a defensive, they want to talk about invasions by covering a wedding in a tabloid magazine. And the original stuff has been completely swamped by the newsworthiness privilege in modern day. But there are other things that are very different, and we do this. You don't need a dignitary interest if it turns out that the invasion of privacy involves some false light. That's a kid's sister to defamation, where there's force and fraud. And the single most important element by far in this area is the use of name and likeness, which is not a tort about being falsely exposed. It's a question of who gets to promote the name of somebody. I recommend to everybody watch the movie Air, because what happens, you get Mama Jordan, who basically wins the prize for the smartest person negotiating ever. And she goes and says, my son Michael, you want to give him $250,000? That's nice. But you forgot to mention a share of the rights from the profits of things sold bearing his name. I don't want it for anything else, just him. Well, it turns out those rights, those little extra things, were worth 1,000 times the fixed fee in that particular case. And when Phil Knight agreed to do this after being somewhat poleaxed, he made himself a billionaire at the same time he made Michael Jordan a billionaire. So, I mean, you've got a real concrete interest in that particular case. And it's not just dignity that's at stake, it's just hard cash dollars. Well, the other thing I want to do is to mention there's a third problem, which I don't think is there, about how you deal with standing. I'm a passionate defender of broad standing in some case and a fierce opponent of it in others. And let me explain what I think the difference is. There are many cases in which you have some government action which is ultra virus, meaning in effect, they really can't do this sort of thing. And so the question is, who can stop that? Well, take the analogies to both corporations, charitable organizations, local governments, state governments, and so forth. The general rule is if your government wants to go beyond its power, any citizen can authorize or bring a suit to say they're not allowed to do this. It turns out it's a pretty easy up or down determination, whether it is or is not constitutional. You could amalgamate suits when people have different sides and come up with it. And what you don't want to do is to have the travesty, which we may well see, for example, in something like the student loan case, where so it's always only the distribution of publics. There's no special harm to any individual. So there's a bill that tries to relieve you have $500 billion worth of debt, and nobody can challenge that. That to me is the absolute madness that associated with this system. And if you go back and you look at the statute, which talks about all lawsuits in law and equity, ultra virus suits in a court of equity were absolutely common business. And the Supreme Court never gives any attention to those words when it talks about discrete injuries. It's just a plain constitutional historical blunder. But when I talked about cloud with cliffs, it's a very different kind of problem. Because there, everybody admits that the agency has some control over this. And if you start to allow standing to come from every private individual who wants to take a decision and tweak it in this direction or that, and then you get a system where essentially all administrative law is going to be undermined. So I think that the ultra-virus is an exception to a general rule that when you're dealing with these things, you have to be relatively careful in the way you look at these agencies. There are matters of statutory interpretation, which we didn't really talk about very much, but I've always been in the anti-Chevron camp. My view about major questions is it doesn't go far enough. It says some questions we really care about, others we don't. What's the line between major and minor? It's actually very hard to draw, as the case going up with respect to forcing people to take government inspectors on boats will show just how difficult this thing is to turn out. But that's a different kind of problem. And so I think what happens is you want to draw that particular line. And I don't think Karen could object to this on the ultra-virus line. I think she could object furiously, as she does, to the situations where you have these private attorney generals bringing suits representing one interest, stopping a program, which essentially has a minority view on a political question, where it turns out that the tiny little voice on the extreme basically dictates the show for everybody else. So that's what I wanted to say.
Excellent. Well, I want to remind the audience that the Q&A button is at the bottom of the screen. We're going to get to the audience questions in just a minute. I want to see if Karen or Matthew have any responses to anything that they heard Richard just say. And then I have a couple questions I want to ask the panel, and then we'll move quickly to the audience questions. And there's a great set of those, and we'll have a robust discussion through those, but there's room for more. So if anyone wants to add one, please.
You got a long list.
What was that, Richard?
We got a long list of good questions.
Yeah, we do. Definitely. Anything, Karen or Matthew, you want to add right away?
I'm good.
All right. Well, let me ask this question then. I just want to tease out the meaning of a few things that have already been presented by all of you. The first is, I think a number of you have talked about this idea of the citizens perhaps suing when the government wouldn't. And so can you explain a little bit about the history of prosecutorial discretion and the role that prosecutorial discretion has generally played in the legal system, and how that that very idea is either facilitated or undermined by the existence of either a complementary or a substitute private right of action?
The prosecutorial stuff is obviously undermined by private rights of action. Nobody in the world has figured out a way to avoid prosecutorial discretion. There's at least one effort in the courts for saying that if you exercise prosecutorial discretion, there's a difficulty associated with the non-delegation doctrine, which I regard as a kind of intellectual form of madness, because it's inescapable. Why is that? Because the ability to bring a case depends, A, on your interpretation of the law, and B, on the huge agglomeration that you have with respect to the facts in question. So if you're trying to limit this sort of thing, essentially what you do is you have two barriers. There's one which is sort of the explicit racial barrier on the sort of heightened scrutiny for that area. And then a case in which somebody announces, I am hereby engaging in selective prosecution against this person, but not anybody else. And Alvin Bragg is a potential candidate for that. But over every other kind of area, there's just too much going on. And so the proper response is, if you're running an elaborate department, you have to worry about parity across situations. And so what you do is you have a central panel that reviews these cases to both set the substantive standards and to avoid the kinds of anomalies that are put into place. And that, I think, is the correct response. It's an institutional response rather than, for the most part, an adjudicated response. And then when the defendant is prosecuted, he, of course, can start to say, this is really, I hate to use the word, a trumped up prosecution of one form or another in an effort to get that thing in there. Usually, it's not something that's going to be decisive. Abuse of prosecutorial discretion, if you're sued, what you're going to have to do for the most part is to prove that he's wrong.
I would just say, I agree with that. I would say that, another thing that can happen is kind of like the EEOC structure, where people are allowed to file complaints, right? Especially those that have been harmed. I mean, again, it's the lack of particularized injury that's I think most pernicious with this in those cases. But anyway, you could have a whistleblower or something like that, but at least then you're engaging the executive to look at the landscape and, see how this is enforced and use their discretion, so that we're not counting, a minor violation the same as a bigger one. We have, again, maybe potentially a right to cure, so that you're you're really targeting the bad actors, as opposed to those that, just didn't know this was, something they were not, a law they didn't know about. I just think having that centralized enforcement mechanism is also just very critical to make sure that everybody's treated the same under the law. And these citizen suits, it's just not that way. It's just whoever finds out about it and has the resources and wants to go, sue against, another entity.
Just to add, I think that highlights a really important point, which is, in these discussions, there can sometimes be a false dichotomy, right, between public enforcement versus private enforcement. It's either the agency or it's either the private lawsuit. And there are actually a number of kind of hybrids in this space, where both have enforcement authority, or even when there's kind of overlap in how they enforce. So, you mentioned the EEOC in Title VII, right? The EEOC can even intervene in an ordinary Title VII discrimination lawsuit if it thinks that there's some kind of more systemic interest that would otherwise not be vindicated. So you can imagine giving private enforcement private rights of action, while preserving some kind of public oversight role. And I think going to Professor Koshin's question about prosecutorial discretion, it's not just is the private lawsuit somehow inconsistent with or undermining discretion, but how is that discretion being used? And often Congress puts these kinds of private rights of action in statutes because they believe that the discretion is being ill-used, that the agency is kind of often sitting back when maybe it shouldn't, because it's captured by a special interest or something like that. We can debate, in any particular case whether that's true, but often it's precisely to undercut prosecutorial discretion that we see these regimes being implemented.
Yeah. By the way, the EEOC was very complicated. Originally, they all hated jury trials because they thought of Southern nullification. So they started to create these things as causes of action in equity. And then you had the question, is this a Seventh Amendment violation, which it probably was, but nobody much cared at that particular time. The structure that Matthew says is actually explicitly involved with the National Labor Relations Act. Section 9A has the following provision, which was butchered in a case called Balkensides by Justice White. But the provision said, when it comes to an individual grievance under the contract, that's special industry, and the individual worker has the right to present that particular case. But to the extent that this may involve questions of principle about the interpretation of the collective bargaining agreement, what it also says in the same statute, but it turns out that the union always has a right to be participating in the decision at some level, not to present the case, but if it turns out there's an interpretive issue, which helps this guy but hurts everybody else in the union, what the union can do is to do it. And I thought that this was a very sophisticated accommodation, which naturally meant that it was going to be completely ignored. And it was by Justice White back in a case called Balkensides, about which I wrote my first student note, because I was sufficiently offended by that situation. But all of this interplay, I think, is extremely important. But again, the ultra-virus stuff, it seems to me somebody has to be able to raise that in an appropriate time. And the concrete injury is absolutely antithetical to the equitable nature of the jurisdiction. So I think one wants to sort of to stress that over and over again. It's become just too much of an embarrassment. You find out what is the concrete industry that allows somebody to challenge a $500 billion appropriation, and it's some data processing center which is going to have expenses that are too high. Give me a break. This is the worst kind of silliness, and the Supreme Court will never back off of its decision that they made for the first time in Frothingham in Massachusetts against Mellon. And the villain of the piece on this one is none other than the namesake of your law school, Scalia, who always was very much about that and then figured out how to do it. If you have to figure out how to find standing when it isn't there, and you have to resort to fiction, then you have to rethink the doctrine from the bottom up. You can't keep on going on with these ridiculous kinds of song and dance routines here and with respect to the COVID cases and everything else.
Let me turn to one other question, which if you can just briefly answer this one.
Oh,
You all have used talked about over-deterrence. And the economic analysis of laws is really all about incentives and disincentives and identifying the costs of action, and part of the costs are the unintended consequences of things. Can you just give our audience a brief 90-second tutorial as a collective group here? What does over-deterrence mean, and why is over-deterrence potentially bad? Right? What do we lose by over-deterrence? Because there's sort of a natural inclination sometimes to say, well, it's not so bad to just protect a little bit more. What's the cost of over-deterrence?
Well, I think the general answer to that question has always been the same. There are activities that you would like to take place. And if what you do is you have over-deterrence, you're going to punish a harm by a magnitude that's larger than its actual existence, which means that lawful activities will stop. Both should join in on this. When you try to teach this, you say, hey, there's enforcement, there's uncertainty. And there's moment that there's uncertainty, there are two kinds of errors. Enforcing something where it ought not to be enforced and not enforcing it where it is. If you don't worry about over-deterrence, you only worry about one form of mistake, which means that you're going to push things much too far, which means that businesses are not going to engage in serious kinds of activities that they ought to be able to undertake. And so, for example, if you assume that no matter what you do, there's always going to be some kind of ambient air quality violation that private people can sue for, people are not going to start to build the fossil fuel plants, which may well be cost justified as compared to their other kinds of situations where there is. And what often happens is even worse. You get over enforcement with respect to one kind of peril and under enforcement with respect to another. So you go absolutely crazy about the effects of fossil fuels on temperature, wildly overstated. And then you ignore all the distortions that take place with wind and solar energy in terms of how you build the plants together, what they're needed for, killing birds or whatever it is. And you cannot run a regime in which you consciously do both mistakes. This also says one of the things I truly hate about the Copyright Act is the mandatory $25,000 fine, right, for trivial violations. That has huge deterrent effects that you really don't need under these circumstances, and it stifles speech of all sorts. I wanted to publish an article on some of these things, and all these guys are saying, well, I don't know if you could use this particular graph, because if you put it in there, it may not be fair use, at which point we could be responsible for paying $25,000 when we take it out on a notice. So it's a serious issue. Do you guys agree with this or not?
Well, and yeah, I think that your point is very well taken, Professor. And I would also just say on the over-deterrence, it's really also, again, the abuse factor, and certain communities can be harmed. In the ADA context, what we have seen in California in particular is, sadly, people that are enforcing that statute, citizens, are targeting minority business owners. Why? Because maybe, they're not English first speakers, and it's really been a problem where you've even seen people on the Democrat side, like Senator Feinstein and others, express great concern for this. Again, so they're disproportionately being enforced against. So it's not even just, over deterrence. It's also what populations you're enforcing against. There's no referee to, make sure that this is more evenly meted out.
We once held a conference at the University of Chicago, which was dealing with disability, and somebody wandered upstairs. And this was a beautifully integrated Saarinen building, right? In which every doorknob is related to every larger architectural structure. And the guy noticed we had the doorknobs, filed a complaint. And so then the law school had to take these beautiful handles, which nobody complained about in the building, and replace them with the levers, right? That handicapped people would do. We also had one industry with it. We had somebody with a terrible set of disabilities And we were told we had to rewire the entire building at X $1,000, very high. What they wouldn't let us do was to substitute in a permanent aid, when the aid would be better able to navigate the building, but more importantly, would take this very heroic student, I might add, and wheel her through the snow so she could go back home, right? So what you do in these statutes with the situation is the Disability Act is a terrible mistake, because what it does is it wants to have easily inspected plant alterations instead of having others devices which would cost less and give greater protection on the other side. And this is the same problem with respect to OSHA. They always want to have something they can inspect, even if it turns out to be very, very bad. So once again, the form of relief that you give with respect to these statutes is absolutely critical. And the sort of uniform injunction in these cases, when it's inappropriate, is one of the costs of their enforcement.
Matthew, any thoughts on that before we go on?
I disagree with the assessment of the ADA. I'll just note that. But on your question about over deterrence, I mean, there's a trade-off, right? And Professor Epstein was alluding to this about over deterrence versus under deterrence. And it's an empirical question whether in any given area one risk is greater than the other. I mean, there is a sense among socio-legal scholars, at least, that in the tort context, in some ways, there's under deterrence because people are disincentivized to sue specifically in that context. As we were talking about earlier, SB 8 maybe over incentivizes, although Professor Mitchell probably thought that was a feature rather than a bug. Yeah.
Well, I mean, he was my student. We had a very spirited debate on this particular question because he is ingenious, and it goes to his writ of erasure fallacy article that he wrote in the Virginia Law Review. I mean, he is the world's most principled man in terms of these things, and strangely ideologically indifferent to some of the underlying stuff. I mean, he is the definition of a formalist in its best sense is somebody who looks within the internal structure of the statutes and try to find out what it does and does not authorize and be faithful to that, as opposed to somebody who's a purposive person, which in some cases manages to get the statute right, and in other cases manages to twist it. So that's a constant problem in statutory interpretation. It came up just yesterday when we had the question of what do we do about the Voting Rights Act. If you looked at that statute, I said it's just an absolute horror in terms of the way in which it's drafted, because it was the only way you could get it through was to make a compromise. And when you have compromises, sooner or later you'll come up with individual cases where it turns out there are things in the statute that point in both directions. Because when you have a statute that insists upon doing balancing and trade-offs, by definition, there are going to be cases that are very close to the line where a shift one way or another will change the outcome. And there's just nothing you can do to start to avoid those kinds of difficulties. If you have legislative indecision, it's going to translate into judicial uncertainty.
So I want to turn to the audience questions in just 1 minute. So Matthew, I have a question for you, and then we're going to turn to those. You had mentioned that one way to approach things would be to say, well, I like them here because it supports my sort of political priors, right? Or and I don't like it here, and that's a way to go about it. I think there is one, even if you take that approach, right? One risk in that is that if you support a particular private right of action as being legitimate in one space, it can set precedent for being used in a space against you at a later point in time, correct? And so even if that's at least a countervailing consideration for anyone who wants to say, well, this is good and good for me here, and I'll just go and oppose it at a later time when it's not consistent with my values.
Yeah, and maybe at the federal level that might give folks contemplating these kinds of regimes some pause. But no, it doesn't work quite as well at the state level, where we have geographic polarization now mirroring our political polarization, right? So California can, enact the gun rights version of SB 8 without worrying about, setting a precedent that the other side is going to use, because the other side won't be in a position to do that. So I think you're right that that might be a break on the politicization or the political use of these kinds of regimes, but it kind of depends on the political circumstances of the particular political community that's enacting them.
Great. I'm going to ask a question from Chris McDonald, and I think, Karen, you hit on this a little bit, but maybe we can elaborate a little more. Chris asks, private rights of action promise deterrence and improved enforcement, but also necessarily more intensive surveillance. To what extent do you think promoting surveillance of citizens by citizens is consistent with existing legal norms and structures? And that's for the whole panel, but I know that, Karen, you had mentioned.
Right. I just, that is a particular concern. In fact, former governor, New Mexico Governor Suzanne Martinez at the beginning of this year had a great op-ed in The Hill about this, about, don't we have enough, incivility is already a problem. This is just going to exacerbate that. And you don't want your community starting to be divided because you don't what your neighbor worried about what your neighbor sees you doing or not doing, and you not wanting to engage them. I mean, I do think that there's an actual real, danger that could happen here if these laws, if more of these laws are enacted, especially when you get into these very controversial social issues. That really is something that needs to be, not only legislated by the, state and federal legislatures, but also, again, enforced by those that we elect. So there's accountability and there's transparency.
Boy, oh boy, I mean, you watch the movies about East Germany and about Russia, what? They're all about citizen enforcement against fellow citizens for activities of defense. And we would regard these things as constitutionally protected, and they regard them as treason. It's a small difference in First Amendment law. But I'm very much concerned about that stuff taking place in this situation, because not only is there accurate enforcement, but thou shalt not bear false witness against thy neighbor, right, is something which can occur if you give people that right. So there are all sorts of stories where there's a private dispute between two people, and the way in which you get even with the other fellow is to make him disloyal to the regime, which would now there. So I just don't like this stuff at all in that particular form. If you're going to do this, I mean, and whistleblower statutes have some of this problem, you really have to go through a very elaborate set of precautions to make sure that poisonous information doesn't come out. And you want to do it mainly against firms rather than against ordinary individuals where they have the ability to monitor and to organize their affairs. But I am not happy with the kind of proposals that are taking place. And again, like Karen, I think it's bipartisan. I don't like it on either side of the political spectrum. Matthew?
I feel like my role on this panel is to say yes, but that's what I most find myself. And yes, I think these are all real concerns. I completely agree with that. The but is the flip side of surveillance is accountability. If there is no monitoring of others' behavior, then people can engage in wrongful behavior with impunity. So again, I think it depends on the precise procedural regime and the features of that regime, whether it goes too far. Obviously East Germany being an extreme example, SB 8 may be kind of moving in that direction, in the sense that invites people without any kind of interest in the other behavior to monitor and surveil others. So again, I agree it's a real concern, but a society in which one another, the citizens hold one another accountable is also a kind of morally attractive vision.
Yeah.
Even though
you hold them accountable in public discourse. You use the phrase too far. Do you remember where that phrase came from? Originally? Yeah, it's the dissent in Holmes's opinion in the Pennsylvania cold case. And he got it wrong in the particular case. But the really deep problem, which I think Matthew's referring to, is how much anticipatory relief do we want, and how much do we want to wait until there's something more concrete manifestation of harm? Common law solution, which I tend to endorse, is if you've always got a damage action lurking in the background for completed harms, you don't want to put the injunctive system in the state into place unless something gets really close to an imminent harm. And the major danger of NEPA, which I referred to earlier, is they want you to cover every conceivable contingency on day one, instead of letting you build the project, and as difficulties emerge, make corrections. I've done a lot of work in construction contracts, and there are full-scale committee devices in which the architect, the builders, and the contractors get together every Tuesday morning at 9 o'clock. So what do we have to work out? and then they work out an adjustment. And the advantage is they have a concrete dispute that they can solve. If you try to work out hypothetically 10,000 disputes before you start construction, you never build.
So each of you have mentioned some of the ways already that we might be able to place limiting functions like, concrete harm. You've mentioned a little bit about maybe fee shifting ideas. Are there any, and I'm going to combine a few different people's questions on this, so I'll try to do all of it justice. Mike Liverite was asking, for example, should we have the losing party be responsible for something? Could it, even if it's not fees, could we require them to maybe do community service? He points out, right? Tom Boyd from Venable has a question also about, can we learn something when we look at PRAs comparatively, especially in comparative jurisdictions where—
Look at what rates?
Comparatively, like in Europe.
Oh, PR, what's the word?
Private rights of action.
Oh, okay.
Is there anything we can learn, especially in systems that may have an English rule component? Does that actually deter abuses in this sense? And then what I want to add as sort of a, so are there things that could be put into the statutes that actually limit this? But I want to add one other audience member's caution on this, and that's from Anne Vroom, who said there's a lot of public discourse about privacy, for example, and these other issues where these private rights of action come up. But oftentimes, interest groups are putting things in the statutes that prevent private rights of action from ever coming into place, and or they put things like caps on damage amounts. And is that, so even if we could come up with ways to limit this, would that be an appropriate to allow for basically lobbying efforts that might lead to those limitations, or the limitations just kind of consistent with rule of law values that we might want to inject?
As somebody who was raised in the English system in my early incarnation as a law student, they did have a winner-take-all system, and it was but the institutional arrangements were very different. In England, jury trials were a rarity, and so you basically get a judge. So now what you do is you have a fee-shifting system, and you get a really militant jury, which is going to start to give very powerful damages to one party against the vast trend of everything else, and then use that as the basis for the fees. The argument that many people have made in the American context is if there's known to be a fee-shifting system, and you don't want a favored class member to have to pay damages or fees to the other side, you let it win, so that it contaminates the other kind of a judgment. And I think that's something that you really have to worry about. In England, they don't give just the fees. They have basically they have a magistrate panel, which starts to figure out which are reasonable and which are not. So there's another kind of check on this. In America, when we have these things, it's often prevailing party only, right? And only on one side, rather, plaintiffs prevailing in a civil rights case. So I think, I would rather undo the asymmetry, but the transplant of legal institutions and rules from one state to another is very heavily dependent on the institutional framework in which those substantive rules operate.
Aaron or Matthew?
Go ahead, Matthew. You go ahead.
Yes, but.
Yeah, so
You lost it, man.
Sorry, I was just going to say the last caveat that you made, Professor Epstein, is crucial, right? That you have to take account of the entire legal system and its different components, jury versus judge trials and things like that, in making these assessments. I mean, even within our own system, right, there are some checks, not necessarily specific to these private enforcement regimes, but just kind of trans-substantively in procedural law. So there's a sanctions regime under Federal Rule of Civil Procedure 11 for frivolous claims and other kinds of abusive actions in lawsuits. There are state law causes of action for the civil analog of malicious prosecution and abusive process and so on. So there are some checks we can debate, whether they're robust enough or whether they need to be beefed up. People have different views about that. But I think there are resources within our own system. The question, and this goes back to, I think, Professor Koshin's original question, is about deterrence versus over deterrence, deterrence, under deterrence, over deterrence, right? Where we're trying to make this kind of complex calibration where we're getting optimal deterrence in neither over deterring conduct that we think is socially valuable, nor under deterring conduct that we think is socially harmful. I think that's a really difficult balance to strike. Again, the worry in some of these contexts is maybe overcorrection, right? That if a private enforcement regime is creating over deterrence, that you kind of remove any kind of accountability mechanisms, and then we get a problem of under deterrence. So I just think it's important to pay careful attention to both sides of the balance.
Yeah, as a litigator, which I do from time to time, regrettably, even the provision that everybody seems to love, that you could bring an action for frivolous suits. It could be that the plaintiff who brings that, well, the party that brings that is frivolous, and the party on the other side is not. One of the things that happens, and I will say this, as a plaintiff's lawyer, okay, as well as a defendant's lawyer, trying to get people to be plaintiffs, even when they have actual injuries of a removal from a board, is extremely difficult to get them to do. And after a while, I didn't understand it, but as they go through it, you do understand it. They risk social isolation. They risk being attacked in collateral provisions. They risk being told that they are engaged in frivolous activities. There is no way that you can be a party in a litigation in which you only can deliver blows without receiving them. And the moment it turns out that there's this bilaterality, what happens is getting private plaintiffs to sue is very hard. So you get this kind of situation. You get institutional claimants, right, who are bringing all these things. They don't have that. But if you actually try to get individuals to do it in their own right, it turns out I would say 80% of the people I've approached or more have simply said, I don't know what's going on here. Thank you, but no thanks.
The only thing
No, go ahead, Karen.
could add, one of the things that we really haven't discussed a lot today is a lot of these statutes at the state and federal level are not just allowing citizens to sue to enforce the laws, but incentivizing them to. They're literally bounty hunter provisions, creating cottage industries of attorneys bringing these suits. And that is, in my mind, the absolute worst example of this, because there's no win for the person that's the target of those suits. I don't even think a loser pays works in that situation, because honestly, I think they get extorted on the front end.
Yeah, and the people who bring these suits, they're not random individuals. They're guys who specialize in this stuff.
Right.
It's like, to give you the analogy about shoplifting, the original version about this was, oh my God, these poor people are so desperate and hungry. We have to give them some excuse. And then you look around, there are a bunch of guys with gangs who have a calculator to see how much they could get before they're going to be prosecuted. And so the selection effect is enormous on these things. And it's just very dangerous when you have you have to know who is going to be able to come forward on these cases, because it makes an enormous difference on whether or not the abuser is the plaintiff or the defendant. The general principle is you do not know a priori who's wearing the dark hat and who's wearing the white hat.
All right, 30-second answer on this one, please. So is there a concern, and this comes from Tom Boyd again, is there a concern about a disproportionate portion of any eventual recovery going to lawyers rather than victims?
Yes.
Yes, absolutely.
Particularly in class action contexts. Particularly
with lightning round for our last couple questions. First off, would it be appropriate, this is Steve Del Bianco, is it appropriate that a school district can cite a nuisance statute to bring a private right of action against social media platforms for non-specific harms to teenage users? Is that?
I would oppose to that.
Public nuisance has become the #1 abuse sort in all of these cases. Everything that's wrong in local enforcement is now attributable to a car manufacturer. And so,
and I will just add that we have had some past programming on that, and I encourage you to go to masonlec.org to see that. Also, Richard has a paper among a set of 6 papers that were in the Journal of Law, Economics, and Policy last year that also is on these developments in public nuisance. Last question for today is, how does any of this fit into, and maybe this just goes back to the prosecutorial discretion statute or issue, but have we learned anything about the fact whether policymakers, decision makers like sheriffs or county governments and other can just refuse to enforce statutes altogether?
Go ahead, Karen.
all I would add to that is I have spoken to different state people regarding this, and that is one of the reasons why I think these laws are getting enacted, is because of that very concern.
And there's also a concern, say, prosecutor discretion is appropriate, weighing facts and so forth. But if there's a class of cases that is covered, it's much more controversial to decide. I don't want to enforce any class in that particular case, only others. So I'm not going to bring deportation provisions against illegal aliens, only if they commit crimes, right? I mean, that's the kind of thing you have to face. And I think the answer is you cannot do that kind of blanket exemptions.
Well, I want to go, Matt, go ahead. You'll have the last word. Anything on that?
Yes, but
Well, we are at our hour and a half now, and I want to be respectful of everyone's time that's been listening in. Thank you so much to our audience for being part of this discussion. I hope that this is just the beginning of a discussion on this topic. Please know that you can visit masonlec.org to learn about our other programming. You can learn about upcoming webinars as well, including next Friday when we will have a webinar on third-party litigation finance. So we have 4 experts that will be joining us for a discussion on Friday on third-party litigation funding. It includes some who are funders themselves, as well as folks who have had to litigate in the face of some of this funding. And so this is a hot issue that should be quite interesting for us. And we have a whole slew of planned programs coming up. I hope you will visit masonlec.org to see what's happening at the Law and Economics Center more generally. And lastly, I just want to thank all of our panelists here, Professor Richard Epstein, Karen Harned, and Professor Matthew Shapiro, all for being part of this program for us today. Very insightful analysis, and I really appreciate you all volunteering your time to share your insights with all of us. With that, I wish you all a great afternoon and a wonderful weekend, and please do visit us again at the Law and Economics Center, masonlec.org. See you soon.